Now, an employer does not have to provide a reasonable accommodation if it in fact does impose an undue hardship. That just simply means an action requiring significant difficulty or expense when considered in light of factors such as an employer's size, financial resources, and the nature and structure of its operation. An employer is not required to lower quality or production standards to make an accommodation, nor is an employer obligated to provide personal use items such as glasses or hearing aids. An employer generally does not have to provide a reasonable accommodation unless an individual with a disability has asked for one. If an employer believes that a medical condition is causing a performance or conduct problem, it may ask the employee how to solve the problem and if the employee needs a reasonable accommodation. Once a reasonable accommodation is requested, the employer and the individual should discuss the individual's needs and identify the appropriate reasonable accommodation. Where more than one accommodation would work, the employer may choose the one that is less costly or that is easier to provide. Title I of the ADA also covers medical examinations and inquiries. So employers may not ask job applicants about the existence, nature, or severity of a disability. Applicants may be asked about their ability to perform specific job functions. A job offer may be conditioned on the results of a medical examination, but only if the examination is required for all entering employees in similar jobs. Medical examinations of employees must be job-related and consistent with the employer's business needs. Medical records are confidential. The basic rule is that, with limited exceptions, employers must keep confidential any medical information they learn about an applicant or employee. Information can be confidential even if it contains no medical diagnosis or treatment course, and even if it is not generated by a healthcare professional. For example, an employer's request for a reasonable accommodation would be considered medical information subject to the ADA's confidentiality requirements. Title I also addresses drug and alcohol abuse. Employees and applicants currently engaging in the illegal use of drugs are not covered by the ADA when an employer acts on the basis of such use. Tests for illegal drugs are not subject to the ADA's restrictions on medical examinations. Employers may hold illegal drug users and alcoholics to the same performance standards as other employees. It is also unlawful to retaliate against an individual for opposing employment discriminations that discriminate based on disability, or for filing a discrimination charge, or for testifying or participating in any way in an investigation, proceeding, or litigation under the ADA. Title I is regulated and enforced by the U.S. Equal Employment Opportunity Commission. Title II prohibits discrimination on the basis of disability by public entities such as state and local government agencies, including the LSBME. This means that public entities, including state and local government agencies in publicly owned transportation systems, cannot deny services to people with disabilities or deny participation in programs or activities that are available to people without disabilities. The ADA says that a public accommodation shall take such steps that may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids or services, unless the public accommodation can demonstrate that taking those steps would fundamentally alter the nature of the goods, services, facilities, privileges, advantages, or accommodations being offered, or again, would result in an undue burden. Title II also outlines requirements for self-evaluation and planning, for making reasonable modifications to policies, practices, and procedures where necessary to avoid discrimination, to identify architectural barriers, and to identify how to communicate effectively with people who have hearing, vision, or speech disabilities. Title II is regulated by the U.S. Department of Justice. Title III concerns public accommodations and services operated by private entities. This is not the LSBME. I'm just, for thoroughness sake, I just wanted to alert you to what's going on in Title III. It basically prohibits places of public accommodation from discriminating against individuals with disabilities. These are things like hotels, retail merchants, doctors' offices, golf courses, movie theaters, all of that kind of thing. The Title III sets minimum standards for accessibility for new construction and for alterations, requires the private entity to remove barriers in existing buildings where it's easy to do so without much difficulty or expense. And it directs businesses to make reasonable modifications to their usual ways of doing things when serving people with disabilities. It's regulated by the Department of Justice. Title IV concerns telecommunications. It requires telephone and internet companies to provide a nationwide system of inter and intrastate telecommunications relay services that allow individuals with hearing or speech disabilities to communicate over the telephone. It requires closed captioning of federally funded public service announcements, and it is regulated by the Federal Communications Commission, the FCC.
Yeah, but once I see the number,
Title V is miscellaneous provisions. It contains a variety of provisions relating to the ADA as a whole, including its relationship to other laws, state immunity, its impact on insurance providers and benefits, prohibitions against retaliation and coercion, against illegal use of drugs, and it provides for attorney's fees in the event of a successful lawsuit under the ADA. It also provides a list of certain conditions that are not considered disabilities. So with that as a backdrop, how does this law, the ADA, apply to the LSBME? Well, basically, the way you interact with this law is through the Title I provisions on employment and the Title II provisions on services, which essentially is all board business. The board is a public entity within the meaning of the ADA. So now that we know that that your agency is covered under the ADA as far as having obligations under the law, we need to identify who is covered and has protection under the law. The ADA's protection applies primarily, but not exclusively, to persons who meet the ADA's definition of disability. What is a disability? Well, an individual has a disability if he or she has a physical or mental impairment that substantially limits one or more of his or her major life activities. Also, she will be considered to have a disability if he or she has a record of such impairment, or if he or she is regarded as having such an impairment. So the first part of the definition makes it clear that the ADA applies to persons who have substantial, as opposed to minor, impairments, and that these must be impairments that limit major life activities such as seeing, hearing, speaking, walking, breathing, performing manual tasks, learning, caring for oneself, and working. An individual with epilepsy, paralysis, of substantial hearing or visual impairment, mental retardation, or a learning disability would be covered. But an individual with a minor non-chronic condition of short duration, such as a sprain, infection, or broken limb, generally would not be covered. Now, the second part of the definition would include, for example, a person with a history of cancer that is currently in remission, or a person with a history of mental illness. And the third part of the definition protects individuals who are regarded and treated as though they have a substantially limiting disability, even though they actually may not have such an impairment. For example, this provision would protect a severely disfigured qualified individual from being denied employment because an employer feared the negative reactions of others. And as I mentioned before, the ADA's definition of disability was substantially broadened by the ADAAA, which went into effect in January of 2009. Other individuals who are protected in certain circumstances include those who, such as parents, have an association with an individual known to have a disability, and two, those who are coerced or subjected to retaliation for assisting people with disabilities in asserting their rights under the ADA. ADA disabilities include both mental and physical conditions. A condition does not need to be severe or permanent to be a disability. EEOC regulations provide a list of conditions that should easily be concluded to be disabilities: deafness, blindness, and intellectual disability, partially or completely missing limbs or mobility impairments requiring the use of a wheelchair, autism, cancer, cerebral palsy, diabetes, epilepsy, HIV infection, multiple sclerosis, muscular dystrophy, major depressive disorder, bipolar disorder, post-traumatic stress disorder, obsessive compulsive disorder, and schizophrenia. Other mental or physical health conditions also may be disabilities depending on what the individual's symptoms would be in the absence of mitigating measures, which means things like medication, therapy, assistive devices, or other means of restoring function during an active episode of the condition if the condition is episodic. Certain specific conditions that are widely considered antisocial or tend to result in illegal activity, such as kleptomania, pedophilia, exhibitionism, voyeurism, etc., are excluded under the definition of disability in order to prevent abuse of the statute's purpose. Additionally, gender identity or orientation is no longer considered a disorder and is also excluded under the definition of disability. Now we know what disability is. How do we determine who is a qualified individual with a disability? Because that is the person who is protected under the Act. A qualified individual with a disability is a person who meets legitimate skill, experience, education, or other requirements of an employment position that he or she holds or seeks, and who can perform the essential functions of the position with or without reasonable accommodation. Requiring the ability to perform essential functions assures that an individual will not be considered unqualified simply because of inability to perform marginal or incidental job functions. If the individual is qualified to perform essential job functions except for limitations caused by a disability, the employer must consider whether the individual could perform these functions with a reasonable accommodation. If a written job description has been prepared in advance of advertising or interviewing applicants for a job, this will be considered as evidence, although not necessarily conclusive evidence, of the essential functions of the job. Here are some common questions and answers regarding the subject of reasonable accommodations and qualified individuals. For instance, does an employer have to give preference to a qualified applicant with a disability over other applicants? No. An employer is free to select the most qualified applicant available and to make decisions based on reasons unrelated to the existence or consequence of a disability. For example, if two persons apply for a job opening as a typist, one a person with disability who accurately types 50 words per minute, the other a person without a disability who accurately types 75 words per minute, the employer may hire the applicant with the higher typing speed if typing speed is needed for the successful performance of the job. Let's talk a little bit more about reasonable accommodation. What specifically does it mean to say reasonable accommodation? Well, it means a modification or an adjustment to a job or the work environment that will enable a qualified applicant or employee with a disability to participate in the application process or to perform essential job functions. Reasonable accommodation also includes adjustments to assure that a qualified individual with a disability has rights and privileges in employment equal to those of non-disabled employees. What kinds of actions are required to reasonably accommodate applicants and employees? Well, some examples of reasonable accommodation may include making existing facilities used by employees readily accessible to and usable by persons with disabilities, job restructuring, modifying work schedules, reassignment to a vacant position, acquiring or modifying equipment or devices, adjusting or modifying examinations, training materials, or policies, and providing qualified readers or interpreters. Accommodations vary depending upon the needs of the individual applicant or employee. Not all people with disabilities, or even all people with the same disability, will require the same accommodation. For example, a deaf applicant may need a sign language interpreter during the job interview. An employee with diabetes may need regularly scheduled breaks during the workday to eat properly and monitor blood sugar and insulin levels. A blind employee may need someone to read information posted on a bulletin board. An employee with cancer may need to leave to have radiation or chemotherapy treatments. Reasonable accommodation may also include reassigning a current employee to a vacant position for which the individual is qualified if the person becomes disabled and is unable to do the original job. However, there is no obligation to find a position for an applicant who is not qualified for the position sought. Employers are not required to lower quality or quantity standards in order to make an accommodation, nor are they obligated to provide personal use items. The decision as to the appropriate accommodation must be based on the particular facts of each case. In selecting the particular type of reasonable accommodation to provide, the principal test is that of effectiveness, whether the accommodation will enable the person with a disability to do the job in question. Must employers be familiar with the many diverse types of disabilities to know whether or how to make a reasonable accommodation? No. An employer is required to accommodate only a known disability of a qualified applicant or employee. The requirement generally will be triggered by a request from an individual with a disability who frequently can suggest an appropriate accommodation. Accommodations must be made on an individual basis because the nature and extent of a disabling condition and the requirements of the job will vary in each case. If the individual does not request an accommodation, the employer is not obligated to provide one. If a disabled person requests but cannot suggest an appropriate accommodation, the employer and the individual should work together to identify one. There are also many public and private resources that can provide assistance without cost. What are the limitations on the obligation to make a reasonable accommodation? Well, the disabled individual requiring the accommodation must be otherwise qualified and the disability must be known to the employer. In addition, as we talked about before, an employer is not required to make an accommodation if it would impose an undue hardship on the operation of the employer's business. Undue hardship is defined as an action requiring significant difficulty or expense when considered in light of a number of other factors. These include the nature and cost of the accommodation in relation to the size, resources, nature, and structure of the employer's operation. Where the facility making the accommodation is part of a larger entity, the structure and overall resources of the larger organization would be considered, as well as the financial and administrative relationship of the facility to the larger organization. In general, a larger employer would be expected to make accommodations requiring greater effort or expense than would be required of a smaller employer. Another question that's frequently asked is, must an employer modify existing facilities to make them accessible? And the answer is that an employer may be required to modify facilities to enable an individual to perform essential job functions and to have equal opportunity to participate in other employment-related activities. For example, if an employee lounge is located in a place inaccessible to a person using a wheelchair, the lounge might be modified or relocated, or comparable facilities might be provided in a location that would enable the individual to take a break with coworkers. A frequent question is whether or not an employer may inquire as to whether a prospective employee is disabled. And the answer is an employee may not make a pre-employment inquiry on an application form or in an interview as to whether or to what extent an individual is disabled. The employer can only ask a job applicant whether he or she can perform particular job functions. Now, if the applicant has a disability known to the employer can ask how he or she can perform job functions that the employer considers difficult or impossible to perform because of the disability, and whether an accommodation would be needed. As we talked about above, a job offer may be conditioned on the results of a medical examination, provided that the examination is required for all entering employees in the same job category, regardless of disability, and that the information is handled according to the confidential requirements specified in the Act. After an employee enters duty, all medical inquiries and examinations must be job-related and must be necessary for the conduct of the employer's business. These provisions of the law are intended to prevent the employer from basing hiring decisions and employment decisions on unfounded assumptions about the effects of a disability. A lot of times employers are concerned about whether the ADA takes safety issues into account. And yes, the ADA expressly permits employers to establish qualification standards that will exclude individuals who pose a direct threat, that is to say, a significant risk of substantial harm to the health or safety of the individual or of others, if that risk cannot be lowered to an acceptable level by a reasonable accommodation. However, an employer may not simply assume that a threat exists. The employer must establish through objective, medically supportable methods that there is genuine risk that substantial harm could occur in the workplace. By requiring employers to make individualized judgments based on reliable medical or other objective evidence rather than on generalizations, ignorance, fear, patronizing attitudes, or stereotypes, the ADA recognizes the need to balance the interests of people with disabilities against the legitimate interests of employers in maintaining a safe workplace. Can an employer refuse to hire an applicant or fire a current employee who is illegally using drugs? Yes. Individuals who currently engage in the illegal use of drugs are specifically excluded from the definition of a qualified individual with a disability protected by the ADA when an action is taken on the basis of their drug use. Going along with that question is a frequent question of whether illegal testing for illegal drugs is permissible under the ADA. And of course, the answer is yes. A test for illegal drugs is not considered a medical examination under the ADA. Therefore, employers may conduct such testing of applicants or employees and make employment decisions based on the result. The ADA is neutral on the subject, however, and does not encourage, prohibit, or authorize drug tests. Are people with AIDS covered by the ADA? Yes. The legislative history indicates that Congress intended the ADA to protect persons with AIDS and HIV disease from discrimination. So then you have to ask yourself, how does the ADA recognize public health concerns? And in that sense, no provision in the ADA is intended to supplant the role of public health authorities in protecting the community from legitimate health threats. The ADA recognizes the need to strike a balance between the right of a disabled person to be free from discrimination based on unfounded fear and the right of the public to be protected. We talked a little while ago about different persons other than the actual disabled person who may have a claim under the ADA or rights under the ADA. So you might ask, what is discrimination based on relationship or association? The ADA prohibits discrimination based on relationship or association in order to protect individuals from actions based on unfounded assumptions that their relationship to a person with a disability would affect their job performance, and from actions caused by bias or misinformation concerning certain disabilities. For example, This provision would protect a person with a disabled spouse from being denied employment because of an employer's unfounded assumption that the applicant would use excessive leave to care for the spouse. It also would protect an individual who does volunteer work for people with AIDS from a discriminatory employment action motivated by that relationship or association. So as I mentioned, one of the things one of the important focuses that we had today was on psychiatric disabilities. So we're going to take a deep dive into that aspect, and we're going to focus specifically on individuals with psychiatric disabilities. Psychiatric disabilities have a unique dynamic in the public arena because they are both very common and very misunderstood. One question that gets asked is, how do we even refer to these conditions? Do we say psychiatric disability or mental illness? Well, the truth is that the words psychiatric disability and mental illness are often used interchangeably. The term mental illness is typically used in a medical context to refer to a wide range of conditions related to emotional and mental health. The term psychiatric disability is typically used in a legal or policy context to refer to impairments covered under the ADA. Now, there are a lot of misconceptions about persons with psychiatric disabilities in the workplace. For instance, it's sometimes thought that individuals with these conditions cannot work in stressful or demanding jobs. But in fact, many individuals with psychiatric disability can and do work effectively. How the condition impacts work life varies considerably, and there is no one size fits all. Additionally, it's also not correct as a rule that individuals with psychiatric disabilities pose a danger to others in the workplace. Often, persons with psychiatric disability are more likely to be victims rather than perpetrators of violence. Another incorrect assumption is that individuals with mental health conditions cannot work until they're completely recovered. On the contrary, accommodations enable many with psychiatric disabilities to work effectively with their disability. Some examples of psychiatric diagnoses include anxiety disorder, depression, attention deficit hyperactivity disorder, bipolar disorder, and schizophrenia. Some of the statistics about this area are quite interesting. Overall, about 44 million adults over age 18 in the US report having had a mental health condition during the previous year, representing about 18.5% of the US population. Among these US adults, the National Institute of Mental Health estimates that 18% have an anxiety disorder, including post-traumatic stress disorder, obsessive compulsive disorder, panic disorder, and generalized anxiety disorder. 9.5% have depression, 4% have attention deficit hyperactivity disorder, 2.6% have bipolar disorder, and 1% have schizophrenia. About 18% of workers in the US report having had a mental health condition in any given month. What these numbers mean is that psychiatric disability is one of the most common types of disability covered under the ADA. Using our ADA rubric that we learned earlier, we remember that the ADA defines disability as a physical or mental impairment that substantially limits one or more major life activities. So when an individual has a mental health condition that meets this criteria, he or she has rights under the ADA. The ADA also prohibits discrimination against individuals who have a record or history of a psychiatric disability or are simply regarded by others as having a psychiatric disability. This means, for example, that qualified individuals who have a history of psychiatric disability cannot be discriminated against just because of that history. Also, employers can't take actions such as failing to hire, demoting, or denying training opportunities because they believe a qualified applicant or employee might have a psychiatric disability. The main two rights individuals with psychiatric disabilities have under the ADA are first, the right to privacy. Most applicants with psychiatric disabilities choose not to tell the employer because they fear discrimination. Others, however, do tell the employer because they want to avoid surprise or want to gauge whether they will be accepted as a person with a disability in the workplace. Finally, others simply don't want to live in the closet, as it were, as a person with a psychiatric disability. But it's important to remember that except when asking for an accommodation, the individual can choose whether or not to tell the employer about their disability. The second important right for individuals with psychiatric disabilities under the ADA is a right to job accommodation. Once they ask for an accommodation, the employer can ask for some medical documentation about the disability. And of course, that can't be shared with others in the workplace. If a medical exam reveals a psychiatric disability, a job offer can only be withdrawn if there is evidence that the person won't be able to do the essential functions of the job without an accommodation and can't be reasonably accommodated, or the disability poses a real safety issue. Some of the types of accommodations for psychiatric disabilities include concentration or distraction issues, maybe more frequent reminders of tasks and due dates, a quieter work environment, more frequent short breaks, work from home if that doesn't cause undue hardship for the employer. For individuals who need to have help managing treatment and medication, possibly a flexible schedule to allow for appointments, more frequent breaks for medication, allowing the use of water bottle during work times, and a part-time schedule until the medication plan stabilizes. For persons with anxiety, some types of accommodations include use of white noise earphones, attending meetings remotely, working from home part or full time, exchanging non-essential job tasks with another employee, a change in the management style of the supervisor. Now, sometimes a leave of absence is required as an accommodation, but work leave should be the accommodation of last resort. Whenever possible, workers with psychiatric disabilities should stay engaged in their jobs as much as possible. Sometimes there need to be accommodations to the code of conduct. Employers are not required to change a code of ethics or conduct in order to accommodate a worker with a psychiatric disability. But the code must be fairly and uniformly applied and cannot be applied differently to workers with psychiatric disabilities than to other workers. Oftentimes, there is also a need for accommodation and supervision. So for instance, sometimes workers with psychiatric disabilities ask to be given a different supervisor as an accommodation. Generally, employers are not required to change the supervisor in order to accommodate a worker with a psychiatric or any other disability. But employers can be required to change a supervisor's leadership practices as an accommodation. For example, a worker who has concentration issues might need a more structured supervisory style that involves more task reminders. Now you can see that the large majority of the literature and guidance in the area of the ADA relates primarily to Title I and the employment protections. And then there's a whole other body of guidance and law that relates to physical barriers for services. But it's also relevant to the services provided by the board and to the interaction of physician-facing staff with persons with disabilities. It's important to remember that each such individual must be dealt with on a case-by-case basis in a manner that best permits the individual to receive, as much as possible, the same treatment that a person without a psychiatric disability would receive. So I have to tell you all that when I gave this presentation to the board members themselves, there were plenty of questions and we actually ran over. We have about 10-ish, 10 to 12 minutes for questions. I'm hoping somebody has some so that we can stretch out for the full hour. Mary, did anyone?
If you're on a dial-up phone, you can unmute yourself if you have a question.
I've got a question.
Go ahead, James.
Are the ADA rules applicable to the public coming into our building, or is this just employees?
No, because you are a public entity and you provide a public service. The ADA applies to every individual who walks into your building or calls you on the phone or has any interaction with you in any way. Now, for an individual whose disability is not apparent, not obvious, you cannot be faulted for not taking affirmative steps or action to try to assist that individual or make accommodations for that individual. If, however, the individual's disability or impairment is obvious, you would have an obligation to assist them in arriving at a reasonable accommodation. Or if that person reports to you that they have a qualified disability under the ADA, then, but doesn't know what kind of accommodation they need, there would be an interactive process for the LSBME with that individual. So this would be licensee, a potential licensee, or anybody else that might come into contact with you. As I was saying before, unfortunately, the vast majority of times this arises in either the employment context or the architectural barriers context. That's where the bulk of the laws, regulations, and court opinions come from. But for specifically the work of the LSBME, it would apply equally as well to licensees, potential licensees, or anybody else that you might come into contact with.
Patricia, this is Mary.
Yes.
I have not gotten any emails with questions, but I wanted to just ask you myself, do you think it's appropriate if the license analysts run into a licensee that they're either aware of a disability or the licensee applicant makes them aware of a disability, is it appropriate at that point for them to seek guidance from Ms. James and if they need to from you or I to answer any questions they may have with regard to that?
Yes, if for any reason there's some question, and usually the way that's going to happen in the licensing context is going to be when the person brings it up to the employee, to the staff member. And at that point, it certainly is wise to consult with you and consult with supervisors as to any concerns or any questions that are raised either by the individual themselves, or if the staff member has a specific concern about how to interact with the person. For instance, if it's someone who, for whatever reason, it has communication issues, whether that be hearing or vision or something along those lines, definitely seek additional guidance. That's always smart.
And with regard to licensee applicants or licensees, I guess go with regard to investigations. If something comes up in the course of an investigation or in the course of designing an order, et cetera, that's something that they should discuss first with their director, and then if they need to involve legal thereafter. Is that right?
Yes, that is correct. Again, normally how that's going to arise is it's not necessary. If it's in the course of an investigation, then it probably going to be, if not specifically spelled out, but certainly hinted at in the complaint. The key thing with investigations is, or any kind of disciplinary action, is to make sure that we are mindful of the one size does not fit all motto of the ADA. And that is to say that any type of response or action that is taken for a person with a psychiatric disability has to be specifically tailored to that individual's ability or disability, as the case may be. And there should not be a blanket policy that applies across the board to every person with a purported or documented psychiatric disability without having made an individualized determination as to whether that action or that response or that discipline is appropriate and necessary. And, certainly that would involve some higher level discussions with the subject matter experts in the investigations department, as well as necessary, pulling in you as legal counsel to give the legal framework and context as to how such issues have been handled before, and to point out any pitfalls or things to be wary of based on past experience.
Okay, I don't have any other questions coming to me by email. So do you have anything else left? Would there be a PDF come to us that we could distribute?
Yeah, the narrative of the speech.
PowerPoint.
Oh, yeah, definitely. I can forward the PowerPoint, but those were really just placeholders. If you want a copy of the actual notes, happy to send those to. One of the things we can talk about as far as mental disability is it's important to recognize that this psychiatric enforcement guidance that's been disseminated by the EEOC was originally met with a lot of contention and a lot of disputes by felt that it was extremely overbroad, and it was really presented obstacles to employers and respondents in trying to abide with it. And that has not been the position that the courts have taken. The courts, in fact, have actually oftentimes sided with the employers in the vast majority of cases where discrimination has been claimed based on mental disabilities. And the reason is because there are some procedural and technical requirements contained in the ADA that do create obstacles for a claimant to overcome. And usually the litigation just it gets stopped at the door, in the sense of the threshold question of whether a person actually has a disability, and the person has to prove that he or she has a mental impairment. This mental impairment substantially limits one or more major life activities. And so particularly, excuse me, when you're talking about the constituency that the board deals with, presumably someone who has been able to complete the required education and training to be eligible for licensure without more, or who is a practicing physician or other allied health professional, it is not likely to have a chronic mental disability that would satisfy the ADA. It may come up in terms of episodic or something that has arisen later in life or after the individual has been in the profession for a while, and that certainly may be the case. But because you're dealing with a narrow pool of individuals who are not likely to have such problems as a wide swath of persons, it will hopefully be a relatively infrequent experience that you're ever going to have to deal with this. But because it has come up in the past, it's good to be armed with just enough knowledge that you at least know the old saying, you don't know what you don't know, and at least this puts
good news and the bad news.
puts you all on notice. It gives you a little bit of context and background that you can maybe in the back of your mind going forward, it might prompt you to ask the question either of your supervisor or of your supervisor's supervisor or legal or such like. And I think they will spot us 2 minutes on our hour requirement. So if y'all are happy with with being done,
All right, I'll come and pick them up. Okay, bye.
Unless anybody has anything else to close, we can just call it a day. You can always contact me, Mary and Dr. Collada and Alan. All have my contact information. If you have any specific question that ever comes up that something I said didn't make sense, or if you actually have a desire to read through these notes, something you read doesn't make sense, you can always contact me at any time.
Okay.
Thank you so much, Patricia. We'll make sure everybody gets the documents that you send.
Very
Thank you,
good.
Miss Patricia.
Thank you. My pleasure. Enjoy your afternoon, everyone.
Thank you, everybody.